little over an hour ago, we got the ruling from the judge in White County, Illinois. The judge in White County, Illinois granted the restraining order against the governor and the attorney general and anybody else acting through them from enforcing this gun law against all 1,690 of our clients in that case. So those 1,600, and there's about 65, I think, I don't have the exact 60 something FFL dealers in there who are now free to operate as that law never passed. For those of you on there that aren't FFLs, you're free to act as if that law never passed for now, unless the Supreme Court might say otherwise at some point in time. But for now, that's not the case. Ryan has sent all of you a copy of the order along with the list of information. If you have any thing you don't understand, let us know, but it's pretty straightforward, okay? So the judge that issued the ruling in White County did an excellent job in his order. He said two things that I think are important for you guys to understand. One is that he, in addition to the judge in Effingham and in addition to the appellate court in Mount Vernon, implored the Illinois Supreme Court to revisit these procedural games that the legislature plays with the 3 readings rule of the Illinois Constitution. Everybody knows they play the game. The attorneys for the defendants came to court and said, yeah, they're too bad. There's nothing you can do about it. And there is someone that can do something about it. It's called the Illinois Supreme Court. So that is exactly what this judge in White County has said again. This is a problem. It's a big problem. I can't deal with it at my level, but you can deal with it and you should deal with it. Okay, so we will get to at some point the Illinois Supreme Court, and the Illinois Supreme Court is going to do one of two things. They're going to say we're going to continue to allow the legislature to play these games, or we're going to put an end to it. And hopefully after 2 additional decades of them playing this game, our Supreme Court says that's enough. So that was a good thing. The other thing the judge did is he even gave his own explanation of the violation of the Equal Protection Clause of the Illinois Constitution. Again, this is not a Second Amendment argument yet, directly on point. We're saving that for if and when we have to deal with it. But I would ask you to consider that if we don't have to fight the Second Amendment fight yet, that I'm going to use a weapons vernacular. Let's save that bullet, right? We're going to save that bullet. Right now, we've got equal protection under the Illinois Constitution that 3 places, 2 county judges and an appellate court have said this is a huge equal protection issue. And I agree with them. So the Illinois Supreme Court is going to eventually, the Illinois Supreme Court is eventually going to have to deal with this issue. Here's the concern, and it's not a big one, but it's a concern. These other outlier cases that we've got going on right now, I'm not going to mention them. You know who they are. I don't want them to screw things up, because here's what the government's going to want to do. They're going to want to hurry up and rush to the Supreme Court. Like, let's go. Let's get to the Supreme Court without doing any discovery, without going and asking any questions of Speaker Welch, Senator Harmon, or any of them about these problems. They don't want us to ask them any questions. And so they're going to try to find one of these cases, not our cases, because I'm not going to stand for it, because it's not in my client's best interest or the people of the state of Illinois to get in some big hurry. Because then it doesn't, I'll get to that in a second. So they're going to try to find one of these other cases, and they're going to try to get that group to run to the Illinois Supreme Court without any information whatsoever other than what we've got. And I just don't think that's a good idea. And I'm hoping that they don't do it. And I'm asking them not to do it. I'm asking them to, let's just take a few weeks, month. Let's ask some questions of the governor. Let's ask some questions of the attorney general. Let's ask some questions of Speaker Welch, and let's ask some questions of President Harmon. I just started today on behalf of our clients submitting subpoenas and discovery requests and other discovery mechanisms to get either one, what they got, or just as importantly, show what they don't got. All right? That's what we got to do, you guys. That's what we all got to do. So on our Illinois cases that we have in Illinois, not our federal stuff that other people have had and we're working on, again, for if and when we got to do it, we've got it ready. We don't want to mess this up by getting in a big hurry and getting all excited and somebody letting their ego get the best of them and want to run to the Supreme Court. Don't want to do that, guys. We do that, we are going to hurt ourselves. There's a high probability we hurt ourselves. Okay, so case number 3. If you want to join case number 3, you're welcome to do so. We've gotten to the point right now where case number 3, it's been open for a week. I'm not going to feel guilty anymore if people don't have an opportunity to participate. Again, any opportunity to participate with us is going to end tomorrow night. Doesn't mean you can't find another lawyer or another group that might want to do something. That's great. But any opportunity or windows with us is going to be tomorrow night. And then we're going to get it filed. And absent something changing that I'm not aware of in some other court, the Supreme Court won't, by then, the chances of that restraining order getting entered in that case are highly likely, right? Because there's this appellate court case. So, you know, if that's what you want to do and you want to join us, you're free to do that. You want to join somebody else, you're free to join them. Want to go file your own without a lawyer, you're free to do that too, right? Nobody is, you know, suggesting you have to do one way or another, but ours is going to be available till tomorrow night. Ryan will have the link out there somewhere on DeVoreLawOffices.com. Like to have you. Ryan loves nothing more than answering 600 to 1,000 emails a day. He needs a few more emails. You guys know Ryan loves your emails. So you can do that. Ron Riley, you try to call my office and it's full. Want to make sure that I'm in. Ron, if you got an email that you signed a document and then it said thank you, you got another response, then you're in. If you have not received that, then you need to send an email to Ryan. Again, if we answered the phone all day long, brother, we wouldn't be able to help any of you. So send the email asking Ryan if you're in. But if you look in your email and if you got a, you know, when you sign up, you're going to get a receipt that you've signed up, and it'll say within 24 hours you're going to get another email asking you to sign. If you get that other email and it asks you to sign and you sign it, then you're going to get an email that says, okay, that you're done. If you got that, you're good. But if you haven't gotten to that part, then you need to send an email and ask the question. Always watch your spam just in case, because the email systems that we have to use to manage all of that, sometimes we'll send it to your spam. So watch your inbox, watch all your spam folders, because those emails will be coming, okay? And if you don't get them, then send us an email and ask us. AJ, did you just ask that question? Have you heard anything about case 2? Yeah, case 2 order came out an hour and a half ago, and the judge granted the restraining order. There you go, Jenny. Thank you, Jenny. Email just went out on case 2. So y'all got an email on case 2, okay? You're welcome, Ron. Can you come take care of Gavin Newsom in California? That's hilarious. I was in California last week. I love the state, but yeah, I got a JB Pritzker. I don't need a Gavin Newsom too. You guys should take the time, because if you go to our website, we are making sure that, you know, we're acting, when we're representing all of you, we're giving you everything to see, because this is all records we're filing in the court. We're giving you easy access to them so you can see, so you can understand what's going on. Take the time to go read the court's orders. Read the order of Judge Morrison in Effingham. Read the appellate court order that was issued in regard to case 1, and go read this most recent order from White County. Whether you get it on our website or whether you get it emailed to you from Ryan, and really read it and I know it's written in lawyer language, you know, but I grew up in a trailer park. I had to learn lawyer language. You know, I can learn it. You guys can learn it. And understand what the judge is writing about, especially about the equal protection, right? Especially about the equal protection of how they're trying to come into a courtroom and say, oh, it's because of the training of these groups. But there's no information in the legislative record to support any of that. They just made that crap up because they had to make something up to make it sound like, oh, we had to think this through. They didn't think anything through, nothing whatsoever. My understanding is they had to patronize these big groups of men and women because down the road, they didn't want to lose the support of these organizations that these men and women are part of. That's what I'm told. You guys can assume whether you believe that's true or not. Again, I'm not telling you I know for certain because I only know what I was told, but sounds plausible to me. Let me see here. All right, I think that's about all I got, but let me see here if you got anything else. Let's see here. Yeah, can you tell me why the appellate judges ruled against 1 through 3 in violations of the first lawsuit? Keep in mind, to say that they ruled against, it's not that simple. As to the 3 readings rule that we raised, they didn't rule against us because they disagreed with what we argued. They only said that we don't have a chance of proving that at this level of court because only the Supreme Court of Illinois can give us what we're asking for. And the appellate court said that they should give us what we're asking for because it is a violation of the procedural requirements of the Constitution. So it's not that they disagreed with us. They just said that they're at their level of court, at the appellate court level, they don't have the authority, and it takes the Illinois Supreme Court to issue that ruling. And again, all of these judges have said, Supreme Court, you need to do this because it's gone on long enough. I hope that makes sense. I'm not going to talk about Representative Calkins anymore. I've said my piece on that. I just hope that his case doesn't mess our cases up, you guys, because there's a chance that it could, and it's unfortunate, but I can't control that. I don't know how many people are in case 3. Is it Gustav? I have no idea. If I had to, I mean, that's all Ryan does, all that work. And I don't even think he knows until, because it automatically, Ryan has spent a lot of time and we've invested a lot of resources in developing that infrastructure that keeps track of all of that. Okay. And so, sorry, my phone beeped. And so that all is populating and then he manages it, but it's, I don't understand any of that stuff. Okay. Is a temporary restraining order good until it goes to the Supreme Court? Yes, it will be. Yeah, tomorrow night on number 3, you guys. I'll leave on number 3 open till tomorrow night, and then Ryan will spend the weekend answering your emails that he loves to get from you and getting everything organized for us. Brandon, thanks, Tom. I just got up. You must work midnights, or you're a 19-year-old like my kids, and they get up at noon because that's what teenagers do. Can you explain the GLA? I don't know what GAL means. Rebecca, what's GLA? I don't know what GLA is. Make sure I don't have any more questions. So I get back to issuing our discovery requests. Oh, Guardians of Liberty. Okay, yeah. Guardians of Liberty. We created an organization. It's an association. It's like the Gun Saves Lives, or it's National Rifle Association. You can create an association. It's actually formally created under the laws of the state of Illinois, and people can be members. It doesn't cost anything to be a member whatsoever. There's no financial obligations to be a member. ever that you can say, I'm a member now, I don't want to be a member next week. It's voluntary. That's what the point of it is. And so we created the Guardians of Liberty for two purposes. One is that if we're going to, as a group, decide later that we want to fight the FOID card or we want to fight other things, we have an organization that you guys can all right now who are in these three cases, you can be a member. It doesn't cost you anything. And again, if you're a member now and a month from now or 6 months from now, I don't want to be a member anymore, you don't have to be a member. But we've created that because, again, when we get into the federal court, for procedural reasons, that's a whole lot easier for our association to deal with that than hundreds and hundreds of individual people. And your rights are protected just the same by doing it that way. So, again, then we have that. It's ours. I mean, again, it's yours, really. And again, it's not going to cost anything, you guys. It's never going to cost you anything. One person asked that question. They sent Ryan an email, and it's like, no, it's never going to cost anything. So that's what we're doing it for. It's a good thing. And I've got it all set up. It's all got bylaws. It's all, again, perfectly appropriate. And all of you, again, that are in case 1, 2, or 3, you need to join. It's not going to cost you a thing. It'll never cost you anything. Okay. Yeah, Matt, you just print off the restraining order that'll have all of your names on it. And again, if you go to any of those firearm or FFLs that are on there with you, you guys will all have that document. So Accuracy Firearms, it was in case 1, they've got a print off of it at their store anyway that has everybody's name, so they know. How do we join, Jeff? Jeff, you can, Ryan will post a link. There'll be a link that'll pop up there, Jeffrey. You'll see it in a second. Number of people badmouth. Who's that? Jeff? No, who said that? That was Mark Fisher. Nobody has to join if they don't want to, right? That's okay. They can go do something else. But, Ryan spends 18, 20 hours a day. I probably spend the same. I've got 2 other staff members that work on this stuff full time, answering hundreds of messages a day. We sent out 50 subpoenas yesterday to all of these sponsors of the politicians and Discovery. And this is just getting started. This case could drag on for 2 or 3 years. So, I mean, people don't have any idea of how much work it takes to do this kind of stuff. Somebody tried to join the Guardians of Liberty, but the link was broken. Is there a corrected link? Linda asked. Ryan, you'll have to deal with that. Johnny, I'd print a copy of it off, Johnny, just to be prudent. Have it in your hand. Again, if you go to one of the FFLs that's listed in the case, they may have a copy of it, but I'd just print it off, Johnny. There's no bright line right or wrong answer to that, but I would just have a copy of it to be prudent.
Hey, Tom, there's a lot of questions that people don't understand that they have to be a plaintiff to join Guardians of Liberty. It's not
yeah. Okay. Thank you, Ryan. Yeah, if you're on the Guardians of Liberty, you guys, right now, the membership is solely for those who are in cases 1, 2, and 3. Okay. Those are the members because that's what giving them membership. It doesn't cost them anything. It's not even open to other people right now. And again, I've not thought of any point in time where it might be if we've not done that thinking. But as of right now, if you're a member or you're a plaintiff in one of the 3 cases, you're automatically allowed to get in. And again, it doesn't cost anything. It's never going to cost you anything. Okay. So somebody sent me a message and they just don't understand, how much is that going to cost me? It's going to cost you anything ever. So hope that answered their questions. Patty, no, we didn't say what time. We'll put the timer up on the website, Patty. You've seen that before. And 10 o'clock, 11 o'clock, 12 o'clock tomorrow night. I'm not sure. It'll be later in the evening. Yeah, it's funny. If anybody wants to try to manage all of the relationships with hundreds of people at once, everybody feel free, go ahead. Mr. Calkins tried it. It didn't work out real well for him, did it? It's not easy. Jeff says, are we automatically members of the Guardians at Liberty if we're in the lawsuit? Not automatically. you're going to get a link from Ryan, Jeff, and you have to click on it and say, yeah, you're fine with being in. I can't put you in it just because you are part of this suit. I can't just say, oh, you joined the suit, so you're in the association. That's what Mr. Calkins tried to do. That's not appropriate. You're going to get a link, Jeff, and it'll say, yes, you're in. I'm just saying that if you have to be a member or in one of these suits in order to be asked to be a member, and then you click on it and say yes. Hope that answers it, Jeff. Jenny says, I've not received the link yet to Guardians of Liberty. If you're on case 3, then you wouldn't have received the link yet. We're waiting until after we close that out, and then you'll get that if that's you, Jenny. If you're in case 1 or 2 and you haven't received the link, that's a Ryan question. Samantha, I'd print out the whole thing that has your name on it, right? I mean, just because you want to make sure. There's actually a list. There's a list of the people that are in that case attached to it. So I wouldn't just print the first page, Samantha. Well, you guys know what happens. I'll explain that to you. When you got these big associations, these big groups filing these cases, you realize that they get exorbitant amounts of, and I'm not criticizing, I'm just telling you how it works. They get exorbitant amounts of resources from people with a lot of money, right? So they have lawyers working and staff working on those cases that those associations bring. They're getting money from large groups of people that have a lot of money. And they're also asking people like you for donations, send money to the NRA, send money to the state, right? There's nothing wrong with that either. You can do that. Well, with what you've done, if you've joined one of these cases that we filed or one of them that there's been some other lawyers file, you're hiring a lawyer directly instead of giving your money to an association and them going and doing what they want with it. It's not really any different. You have to choose what you want to do. If you want to send your money to the NRA or to the State Rifle Association and then let them do with it what they think they need to do, there's okay. Again, they're not really any different, from a broad perspective. It's just you're choosing to say, I want to be a part of this. I'm going to be a part of it by actively engaging somebody to help me directly instead of just being, again, in the NRA or something. There's nothing wrong with either one. Absolutely not. No, John, they can't do that. Matt, I'm having a question. What is tonight's bourbon? I don't know. I got a Whistle Pig 18 in there, if you know about that. Maybe I haven't opened it yet, but maybe we'll have to break it out. I think that's it, Ryan. So if equal protection, this is a good one. Who's that? The dude. So if equal protection argument gets upheld, does it help the Second Amendment argument? Because if equal rights is being violated, then that means semi-automatic rifle should. They're really two different things. And if our state court equal protection argument is upheld, then we don't even get to the Second Amendment argument, right? You don't have to get to it because, it's a completely separate and independent legal analysis of, equal protection and Second Amendment. So if the Second Amendment's been violated because the law is discriminating against, the citizens of Illinois disproportionately, Second Amendment conversation, we don't even get there. We save that for a later day to argue of whether or not a ban like this violates Second Amendment. That's ideally what I would like to see. We don't even have to get to Second Amendment. We're going to save that one, right? And we use that one if you try to bring this law back around at us again. You know, we can still make it, but again, I want to make sure you're clear. If you win the equal protection, then you don't even get to the Second Amendment because it goes away on equal protection. Let me make sure I'm done here. No ISP cannot enforce the ban on current members of case 1 or 2 as of today because there's a restraining order, so they cannot enforce it against them. Let me see here, make sure I'm done. You think the Illinois will use the National Guard against us? No, that's not going to happen. Not going to happen. Make sure I'm done here. Okay, so I'll give the recap again, and then we'll finish it off. So the restraining order is still in place in case 1. The appellate court issued their ruling in case 1, upholding the temporary restraining order based upon equal protection grounds. They also raised concerns that they want the Supreme Court to address the 3 readings procedural violation. In case 2 in White County, the judge just issued that restraining order an hour and a half ago, almost 2 hours ago, granting the temporary restraining order as to all the plaintiffs in that case. Same reason, he said equal protection's clearly been violated in his opinion. Also raised the issue of the 3 readings rule, a procedural constitutional problem. He said that's a big problem. The Illinois Supreme Court needs to address it. We're working on case 3. It'll be open till late tomorrow night sometime, and that's going to be it. If you want to join, you can. You know, you might find another lawyer now that we've got these rulings that might want to do something in your part of the state. That's great if they want to do that. If you want to be a part of ours, that's fine too. You choose. Ryan's working on the documents as people, you know, request. If you want to request it, it's at Ryan will have the link out there at devorlawoffices.com. And I've started discovery on the cases, asking questions and subpoenas, trying to get to the bottom of this. To the extent you know people that's in any of the cases that's not ours, that are involved in those cases at a high level, just tell them don't get in too big a hurry, okay? We don't want to rush this because right now we're sitting in a pretty good position, and I don't know the ultimate outcome, but rushing it would not be favorable to us. So you guys have a good day. I'm going to get back to work. I love you. Tom's out.